Um, First of all, I'm going to look at the fact that there's no Labour chapter in this agreement. I had the easiest job of analysing the legal text for this part because there is no legal text for the Labour chapter. But I do want to say a few words about this because it's obviously a key criticism going forward, and something we shall be raising politically and campaigning on going forward. When we look at the countries, the RCEP countries, over half of the 15 countries party to the RCEP agreement are actually ranked amongst the worst countries in the world to work, where workers effectively have very little rights. And this is according to the ITUC, the International Trade Union Confederation's 2020 Global Rights Index. So we're dealing with countries which are have very serious concerns, yet there is no Labour chapter whatsoever. And there are numerous examples we could give. So whether it's child labour in Cambodia, I was looking through the list of products which the ITUC see as having child labour as products in Cambodia. We're talking about alcoholic beverages, fish, meat, rubber, salt, shrimp, sugarcane, textiles, or whether we're talking about the arbitrary arrests and detention and imprisonment of trade union leaders. There are various countries where this is, of course, a huge issue, whether it's Cambodia, Indonesia, or the Philippines. And of course, China's record is extremely bad, with 1.8 million Uyghurs and ethnic Kazakhs and other Muslim minorities that have been detained, and there are severe human rights abuses, torture, political indoctrination, and of course systemic forced labor, which is now occurring in these mass internment camps, and constitute crimes really against humanity, and many of our global supply chains are at risk of tainted goods made with forced labor. So this is a huge issue for us, and while there's no legal text on this, and we will be raising it considerably. Now, I just wanted to turn to the chapter on the temporary movement of natural persons, chapter 9, and in particular Annex 4, which relates to the actual commitments that Australia made on temporary movement of natural persons. Often DFAT will highlight that it is just business or very high skilled business visitors or very high skilled professions that are part of the temporary movement of natural persons in this agreement. But when we look at the actual legal text, there are provisions for intercorporate transferees, contractual service suppliers, and independent executives. And all three actually link and relate back to the temporary skills shortage visa, which has a very broad range of occupations, and much broader than simply business executives. It's around 430 odd occupations, and there is both a short-term skills list and a long-term skill list. And of course, we know that many of people on those occupations are actually doing even lower skilled occupations than what are actually on the list, and are deeply and are often underpaid. And there's numerous studies highlighting the exploitation of these workers. So it's quite this chapter does link on those three examples, on the intercorporate transferees, the contractual service providers, and the independent executives. Now, but what we know is, and what we normally look at in this agreement, is whether labour market testing has been removed for this section. But but actually because of all other trade agreements with the RCEP countries, labour market testing has been removed for all RCEP countries already. So this is already a problem. And what we've been making the point is that this effectively entrenches already a substantial problem because it doesn't seek to apply labour market testing or reinsert labour market testing. It seems to entrench what are already problematic areas. And of course, when you look at the annexes and you look at what other countries have put forward in the in that chapter, the temporary movement of natural persons chapter, we can see other countries have had greater restrictions on their labour markets. So it's by no means that Australia has to follow that example. If you look at Indonesia, there is an economics needs test, and there's substantial restrictions on a whole range of occupations, for example. So, Australia has one of the most open annexes to this chapter, and of course, the great criticism that we always give is that what they've done is essentially applied the lens of the goods market to the labour market. So they've essentially treated labour market testing as a tariff and something to be removed. But we know the labour market is extremely different to the goods market. So this chapter really just entrenched some of the things that have been contained in other free trade agreements with RCEP countries. I've also been asked to look at the government procurement section, and I just want to read out some of the Article 16.3 on the principles. The parties recognise the role of government procurement in furthering the economic integration of the region so as to promote growth and employment, where government procurement is expressly open to international competition. Each party, to the extent possible and appropriate, should conduct its government procurement in accordance with generally accepted government procurement principles as applied by that party. So there is general principles on expressly opening government procurement to international competition. However, the chapter is actually non-binding and does not have any market access commitments, but it does have a review process. So Article 16.6, the parties may review the chapter within the period stipulated in Article 20.8, the general review, with a view of improving the chapter in future to facilitate government procurement as agreed by the parties. So there is a review process, but the chapter is essentially non-binding. So there are general commitments, but isn't as bad as others due to the non-binding aspect of government of this chapter. So, in summary, our major concerns are the fact that there is no labour chapter at all, and I do wish to highlight that even some of the political parties where we may expect that they would be fighting for a labour chapter have said comments such as, well, these countries are members of the ILO, so there's not so much of a problem. Whereas where we're coming from, of course, is membership of the ILO does in no way at all guarantee good labour rights and those practices. Almost every country is a member of the ILO, and of course, these are fundamental human rights, and they should be part of the agreement. And we will be putting that right at the forefront of our criticisms of RCEP. And on the temporary movement of natural persons, while there is no labour market, while labour market testing isn't removed, it does entrench a position of of where labour market testing has been removed in other agreements, and the intercorporate transferees, contractual service providers, and independent executives are linked to the TSS. So thank you very much.